Well, let's start the second day of the MediMare Mediation in Maritime Dispute Symposium. We have a full day today. It's a committed day to maritime issues and mediation as a means of alternative dispute resolution. And for our welcome today, I will be here in the name of the Coordinating Council of the Institute for Legal Research at University of Coimbra, and also as project coordinator. I'm going to lead this morning the several activities we have prepared, and I would like to welcome institutionally all our guests, all the participants in this event, and as the project coordinator also demonstrate my my happiness that I managed to and we managed to gather that many specialized professionals and also interested persons in our event. So I will start by giving the floor to Dr. João Reis. Dr. João Reis is an adjunct from the Secretary of State for Fisheries, Dr. Teresa Coelho, that unfortunately could not be here, agenda issues, but we are really well represented, and Dr. João Reis will, besides myself, open the work plan for today. Thank you very much.
Thank you. Thank you all. Of course, I will make this speech on behalf of the Secretary of State, who, for reasons of force majeure, can't be present. Our apologies. First and foremost, I would like to express our gratitude to the organizers of the MediMare Symposium for bringing us together today. Its coordinator, to Slovak, and Maria and from the coordinating board of UCLA. I think that this platform provides us a wider space for discussing and addressing the repression issues surrounding maritime disputes and the significance of mediation. Today, I would like to shed light on the importance of the maritime economy and fishing industry for Portugal, the legal framework governing the fishing sector, and the crucial role of mediation in this specific domain. Portugal, with its extensive coastline and rich maritime heritage, has long relied on the ocean for its economic prosperity. The maritime economy, encompassing industries such as shipping, tourism, and now offshore energy, plays a pivotal role in driving Portugal's economic growth and development. Equally important is the fishing industry in Portugal, which has thousands of workers in its ranks, an important local coastal and also international fleets, a rapidly growing agricultural sector, a transformation industry that is among the best in the world. This industry is actually an export powerhouse in the country. An industry that has placed its product fish as the main agri-food product to be exported in our country. But at the basis of this industry, mainly the fishing industry, and to ensure the sustainable management of fisheries and maintain harmony within the sector, a robust legal framework is indispensable. The common fisheries policy established by the European Union serves as a fundamental pillar for regulating fishing activities, complemented by European community regulations and national legislation. This framework set the guidelines for fishing quotas, fishing practices, conservation measures, and the allocation of fishing quotas. While the legal framework provides a solid foundation, the existence of mediation mechanisms in the maritime sector, mainly in fishing, could be of paramount importance, especially in resolving the complex and diverse disputes that arise within these industries. Mediation as a mechanism goes beyond the intervention of courts or arbitral bodies. It seeks to foster a self-composition of interest among the parties involved, aiming for transformative change in behavioral and governance standards. Maritime disputes encompass a wide range of issues spanning from contractual to extra-contractual matters and from commercial and civil disputes, those rooted in public, national, and international law and European Union. The complexity of these disputes arise from several factors. Firstly, they often involve application of different laws due to their international nature, with diverse parties from various regions of the world in different locations. The straightforward application of a single jurisdiction's law becomes challenging. Furthermore, maritime disputes necessitate the consideration of numerous professional, corporal, ethical, and conduct. With an abundance of internal regulations, protocols, safety management procedures, and audit practices, addressing these disputes requires a comprehensive understanding of multifaceted rules and practices governing the maritime industry and fishing in special. Lastly, maritime disputes carry relevance not only for direct stakeholders, but also for the wider public and citizens. Many maritime issues intersect with public and common interests, such as environmental concerns. Consequently, finding resolutions that account for these broader interests adds an additional layer of complexity to maritime disputes. Considering these complexities, it becomes imperative to explore the use of mediation in maritime disputes, especially those involving multiple parties, jurisdictions, and public interests. Mediation offers a platform for open dialogue and negotiation, where all parties can actively participate in crafting mutually acceptable solutions. By involving diverse stakeholders, mediation has the potential to navigate through the intricate web of maritime disputes, fostering cooperation and reaching resolutions that are fair, balanced, and sustainable. Once again, I extend our sincere appreciation to the organizers of the MediMare Symposium for providing this invaluable platform for dialogue exploration. May today's speeches, addresses, debates contribute to a great understanding of the importance of mediation in the maritime domain and inspire us to work together towards a future of peaceful, consistent, and sustainable development. Thank you all.
Thank you for such an eloquent speech, and it's a pleasure to have you here. I hope you expand our thank you to the Secretary of State. And as a small token of this appreciation, I have here a small gift for you and the Secretary of State from our university. So I hope you take both home with you, and that you and the Secretary of State can come back. I know she's from this area, can come back and whenever they wish or are able to.
Well, actually, the University of Coimbra is her alma mater. So she's be very, very happy to.
There will be other opportunities. There will be for sure. We'll continue working on this film and we will ask. And you again.
Thank you.
Thank you. So, não pode passar outra questão. So, we will. Well, let's continue this last part of the morning session. We have now a roundtable on the need for maritime mediation, and I have the honor of having here with me my friend and colleague Leah Vasconcelos. We have Leah that comes from, she's an investigator of the MediMare project and also works at Nova University of Lisbon in Mare. Is very linked to questions of the sea, and she's also mediator in this issue. And then we have Fátima Castro Moreira. She's a professor of the Portucalense University. Her PhD and most of her studies are on the field also of the law of the sea, more specifically. And then we have Vasco Becker-Weinberg, which is also a professor, also in these areas, and he's now the president of the Portuguese Institute for the Law of the Sea. And well, both of them also organized all types of activities in this field, so keep posted. You will start one now, right? Next week on Monday. So what is it about?
It's the summer school.
Summer school.
Well, summer school.
See, from all organizations. And then we have Roberta. She's a PhD scholar here at the student that are at university and the scholarship holder of the project. My right hand over all the project and also specialized and soon will come out with a book under the project on maritime mediation. So keep posted. It will be in open access really soon. It's almost at the end. So and her background is more on commercial affairs, corporate governance. So trying also to link this several dimensions together. So this is our panel. And I will start by asking everyone. We have now a bit 1 hour and 5 minutes. I will ask, starting with the order that I just mentioned, just a bit to relate a bit to your experience on maritime issues, mediation. How does this relate to the project? And do you think that maritime mediation could be a good idea and to which disputes could be applied to? So a very open first impression of your relation to the issue in about 5 8 well top 10 minutes. Perfect.
No, I'm joking.
Well, yeah,
Okay.
you start.
Okay, good morning, everybody. It's great to be here in the closure of a project that has been quite interesting. It has been a great project between us in Portugal and Norway. It was a very collaborative project, and I think in some ways we kind of complement each other. I want to say hello to all of my colleagues of the table. It's great to be in these settings with everyone. But I also want to tell you that my mediation is on the basis. So it's not on the docks, on the basis. I work with the artisanal fishermen. I work with communities. I work with local issues. But I also work with experts. This is more the research projects related, for example, with plastics on the sea and things like that, where I have to involve stakeholders of different views and different types to come out with co-construct solutions. So my point is, I work for co-construction of something. And why is this important? It is important because knowledge is spread all over the society. And particularly in the sea, the issues are very complex and very uncertain. And when we have to deal with that, we need the knowledge of everybody. And one way is really putting people talking, putting people collaborate. So what it shows is that this activity have multi-faces. So for maritime mediation, I should bring all the different perspectives to the same ground so everybody can listen together and can somehow construct what we call in social terms consensual or at least constructive discourse, so that they can define issues and problems together so that the solution can respond to these issues. So this is one of the big challenges of the mediator, and it's something that we have to learn to do more and more before going to the law. That's also important. But if we can put people getting together, talking, exchanging ideas, probably you are giving an opportunity for innovation, an opportunity to construct a new solution that was not on the table previously. And that is only because you are giving space to merging knowledge that come from a lot of different sources. So the sea raises complex and uncertain multi-party contexts that we are challenged to respond And so we have to give more adequate answers and solutions. And for that, we need the collective person. So at the start of the process, I need to put everybody listen to each other so that everybody can construct the collective definition of the problem that we want to get. So here I'll just tell you that I don't work as much with insurance and other stuff. I work mostly with communities and with our local and central administration. These are usually the partners and also enterprises. So these are usually the groups that I work with, and I think it is important to bring off all of them. This can only be done if the parts and each participant listens to the others and also collaboratively build the solution. For the solution, the same parts are challenged to come out with contributions for constructing a solution that goes in direction of all of them. These have some requirements behind, like in mediation, you focus people on interests, and they, with that, have a huge, wide range of alternatives to construct it. As a result, you construct jointly built solutions and sounder and more adequate. Why does this happen? One is the issue of intellectual capital. You bring different knowledge to the table, you allow people to discuss that, and you can build a new solution that was on the table, but actually goes on the direction of most of the interests that are on that table. The second is it constructs social capital. People begin having networks, people begin having partnership, and they also somehow want a solution that goes on the direction of everybody. And also political capital, in the sense that you are constructing what we call in theory, communities of practice. People that get on their hands their future and somehow they are able to proceed with the dynamics you start and also solve other problems when in the future they are faced to it. So thus, if you can construct all these capitals, you have to do a good process to have success. There are some requirements, there are critical factors. That was what we taught on the course. That contributes to what is called today collective intelligence, able to transform our society, able to make our citizens more reliable, more effective, more interventive, and also more participant. So while doing this, we also kind of contribute to the solving of conflicts and disputes, and also create a ground for the future for people to solve them. And so I'm going to refer to what Reese said. Mediation expertise is not mere legal knowledge. It requires training and skills, experience, repetition, repetition, repetition. I have 26 years of going through these sessions. I'll say that I did more than 1,000 collaborative multi-part sessions. And I believe we can use it in different levels, although I really use more at the bottom part, but I really believe people are the same everywhere. And these dynamics are really special and can, in some house, overcome a lot of bad feelings that sometimes comes out of negotiation because one part wins and the other lost. In this way, they somehow accept the loss in a better way. Thank you, that's all.
Thank you, Leah. Let me just intervene immediately. So you are saying that sometimes pure negotiation leaves a bad taste in your mouth. So mediation kind of balances more.
If you allow people to talk and to be heard by the others, you can construct something that at the long range gives you a ground that is more optimistic and less conflictuous. That's the plan, or at least more able to solve the conflicts.
Thank you, Leah. Very interesting. Well, although we've worked together and I know what to do, but for everyone here is an insight from slightly different type of mediation, this co-construction, building, building a bit, building solutions and building communities or rebuilding communities.
Communities are correct, that's
Yeah.
the point. So if we want to change our society, there is no other way.
Thank you, Leah. So now we go to Fatima Castumuret, also a dear friend and colleague, and I give you the floor, my dear.
Thank you. Thank you, Luz. It's a pleasure to be here. Thank you very much for the kind invitation. You know, I'm passionate about sea issues and particularly now my new passion will be sure maritime mediation. So as everybody, or at least those know, and many of you know, my area of research is international law. So my approach is directed towards this branch of law. And the need for maritime mediation in international law is a topic of utmost importance in our globalized world. In an era where the seas connect nations, facilitate trade and harbor resources, it is crucial that we recognize the significance of resolving maritime disputes through peaceful means. Through effective mediation, we can ensure the preservation of international order, the protection of maritime rights, and the promotion of harmonious coexistence among nations. Maritime disputes have been a recurring theme throughout history, from conflicts over territorial claims to disagreements regarding navigating rights. These disputes have often stained relations between nations and even escalated into armed conflicts. The consequences of such confrontations have been devastating, both economically and environmentally, with significant human costs. This is where maritime mediation plays a pivotal role. Mediation is a diplomatic process that brings disputing parties together to find common ground and reach a mutually agreeable solution. It serves as a constructive alternative to litigation or the use of force, allowing nations to resolve their differences peacefully. One key advantage of maritime mediation is its ability to preserve relationships between nations. Unlike adversarial legal proceedings, which often foster animosity and deepen divides, mediation fosters dialogue and encourages compromise. By bringing disputing parties to the table, mediation facilitates understanding, empathy, and identification of shared interests. Through open and constructive dialogue, nations can build trust and establish long-lasting cooperation, even beyond the specific dispute at hand. Furthermore, maritime mediation serves as a platform for finding win-win solutions. By encouraging compromise and creative problem solving, mediation allows disputing parties to move beyond rigid positions and explore alternative possibilities. This approach can lead to innovative arrangements such as joint management of resources or the establishment of shared maritime zones, which maximize benefits for all involved parties. By focusing on mutual interests and collaboration, mediation facilitates outcomes that are not only fair, but also conducive to long-term stability and prosperity. In addition to the practical advantage, maritime mediation aligns with the fundamental principles of international law, including those enshrined in Article 33 of the United Nations Charter. This article emphasizes the importance of peaceful settlement of disputes and oblige states to seek the resolution of conflicts through negotiation, mediation, or other peaceful means. By embracing maritime mediation, nations demonstrate their commitment to the principles outlined in the UN Charter, reinforcing the rule of law and promoting the peaceful settlement of disputes as the cornerstone of international relations. The United Nations Convention on Law of the Sea also enshrines the peaceful resolution of disputes and the obligation of states to seek a mutually acceptable solution. Mediation provides a framework to uphold these principles, ensuring that maritime disputes are resolved in accordance with international norms and standards. It reinforces the rule of law, strengthens the credibility of international legal frameworks, and promotes the peaceful settlement of disputes as a cornerstone of international relations too. So, however, it is essential to recognize that success of maritime mediation relies on commitment and cooperation of nations. States must prioritize dialogue, engage in good faith negotiations, and support impartiality of mediators. Additionally, investing in capacity building efforts and raising awareness about the benefits of mediation can foster a culture of peaceful dispute resolutions and encourage the utilization of mediation mechanisms. So to conclude, the need for maritime mediation in international law is undeniable. By embracing mediation as a primary means of resolving maritime disputes, nations can safeguard their relationships, promote efficient and sustainable solutions, and uphold the principles of international law. Mediation offers a pathway to harmony, cooperation, and the preservation of our shared maritime heritage. Thank you very much.
Thank you, Fatima. Wow. I should say just for, well, for the record, that when Roberta and I gave a class in the intensive course on maritime mediation, and we tried to explain some of the concepts that exist and these arcane concepts sometimes, so that they got a bit of the knowledge of this specificity. There's always, there was one student there that just said, well, but what are we talking about? What is maritime mediation? Are we talking about law of the sea? Are we talking about commercial law and private international? What are we? Of course, law background, right? In this project, we tried, although we didn't pay that much attention because they are full of specificities. Vas will probably also talk about that, to this public disputes, or typically public disputes, this close framework, although we thought about it. And we taught it, no, we thought about it. And of course, we also dwelt then on private conflicts and mixed nature conflicts, such as Leah also explained here, where we have several interests and parties of different nature involved. So all of this shows how rich mediation could be, but we really need to be aware of the specificities of each type and how to draw it in each case very specifically. But I thank you because you gave us this broad perspective on how important is mediation also in this field of state relations mostly. So I think on the same page, I give the word to Vasco Becker-Weinberg and give you the floor for this.
Thank you very much, Dulce. Good morning, everyone. And let me begin by thanking MediMare for this invitation. It's always wonderful to be back in this law school, the oldest law school in Portugal, and one of the oldest in, or second, I think it's the second oldest one in Europe. Still working, yes, exactly. Still working, and so thank you very much. My father is from Coimbra, so there is a connection to Coimbra, nonetheless. And there is, in every institution I work in Lisbon, there's more Coimbra in them than there is probably in Coimbra. And of course, to thank my colleagues of the panel, dear friends and new friends. The question that you raise is quite pertinent. Is mediation a good idea? And picking up on what you just said in your comments to Fatima's presentation, peaceful dispute settlement is always a good idea. It's the only real idea that we should focus on. However, from hearing different presentations, unfortunately I could not be with you yesterday, but listening to different presentations, I believe, because I'm a law professor focusing on law of the sea, but also constitutional law and other realms of public law, I feel that there is an issue also of conceptualization. Are we talking about mediation as a legal process, which Fatima mentioned the international law aspects, but there are domestic mediation as a legal process, or are we talking mediation a very broad, very flexible, that would also include negotiation, where the mediator is an intermediary between two different parties, or dialogue even, or are we really talking about mediation as a legal process? Because if we look at what we see as a concept in Portuguese law, when it comes to voluntary arbitration, we have a law on voluntary arbitration quite established. that notion of arbitration is quite broad. It would fit mediation as a legal process, although it is conceptually a form of voluntary arbitration. So there is the issue of conceptualization, because without that understanding of what concept of mediation we're dealing with, we might get lost in translation, because somebody coming from common law has a very different perspective on how things are done, whereas opposed to a similar process under Roman or continental law family, within the continental law family. And I'm referring specifically to our own influence, but also looking at the German system, how different things can be. Of course, and as Dulce mentioned in her remarks to Patna's outstanding presentation, there are this field of disputes in 2023 are quite permeable. The distinction between the realm of public international law and what we consider actors of international law vis-a-vis what are non-actors of international law, but relevant nonetheless. And I'm specifically speaking to the role of private entities within the international realm. So there are a lot of new gray areas, or previously understood as gray areas, that are gaining more and more space. To give you an example, piracy a century ago was an issue between states, states dealing with private entities, the pirates, and that was seen as a crime under national law. It did develop into rules of customary international law over 100 years ago, but now, when we talk in the last 2 decades of piracy, piracy now is extremely sophisticated, up to the point that pirates have very, very high-level lawyers that negotiate ransom for them, and it's like a movie. Ransom is dropped off by a helicopter, big chunks of money, and that saves a lot of problems to insurance companies. So it makes it easier to release the vessel, to release the cargo, saves a lot of issues. Because if you think of a trickle-down effect, there's nothing worse than maritime law or shipping. Because if you just think that ship that got stuck in the Suez Canal, and you think of the plethora of potential legal disputes that one ship stuck in the Suez Canal can create all over the world, it's incredible. So for insurance companies, the swifter the solution, the better. But that does not mean that it is mediation from a legal concept. I will always go back to this point, because we need to know exactly what we are talking about so we would not get mixed up. Because one thing is to negotiate, another thing is to have an outcome, which is within the freedom of private initiative to establish a contract, and that contract being enforceable in another jurisdiction outside where that contract was dealt, that agreement, that settlement agreement. If a mediator in the UK reaches an agreement, is that agreement enforceable, for example, if one of the parties has assets in Portugal? And then we have a very interesting legal problem, but a very important legal problem, because the validity of the outcome to a dispute has to be enforceable in the jurisdiction, for example, where the assets are placed. So there are many issues here. To highlight one specific issue, an agreement between two parties that are different. Let's say a fishing company, an owner of a fishing company based in Europe, and a union representing fishers in Indonesia or the Philippines, where this fishing company has been seen to employ very aggressive or even hostile or even human trafficking tactics with fishing vessels that are on board. Let's say this vessel has Taiwanese flag, which even makes it more difficult, because Taiwan, as you know, does not have statehood, but the company is based here. So the union in Indonesia decides that we have had enough. We can't sue them in Indonesia. We can't sue them in Taiwan. There's no way we can bring Taiwan as a flag state before an international court or tribunal. Therefore, let's sue the one that's making the money. And they are based in London. So in the UK, I would assume probably it would be possible to find an agreement. Would that agreement be enforceable, for example, if the English company would have assets in Portugal? I doubt it. Because of the nature of the dispute, because of the nature of the parties, because of so there are many difficult issues here that one has to consider when dealing with these issues. The other problem that I see here is also something new, which We have heard in the last week, and it's still ongoing, when it entails, for example, private military and security companies. We see with the Wagner Group. We see them on board shipping vessels, and they're very, very effective to combating piracy, perhaps the most effective measure. But what happens if a private military security company personnel kills a fisher mistaken for a pirate? Often insurance companies, the flag state, there are a huge set of problems to be dealt with. Is mediation a good way out of this big problem? Perhaps not. So there are limits to where mediation can go. And the reason why I think these limits exist has to deal with the complexity. Often a very complex dispute cannot be solved by mediation because of the need to treat evidence, the burden of, the standard of accepting of evidence, collecting evidence, experts involvement. There are limits to where a mediator can stretch, I believe. And therefore, more traditional ways of solving a dispute are also perhaps more adequate. And this brings me to the end of my 3 minutes. I'm sure I went on above that, to two kinds of international legal activities that do involve that connection of those gray areas between the private realm and the public international realm. And that is offshore disputes and involving oil and gas, where you have in disputed maritime areas, where you have a state or two states, that claim a maritime area under which where they've not managed to settle a maritime boundary. Nonetheless, they find an arrangement of a practical nature, and they jointly develop that oil and gas field. But they will not do that through their national companies. They will not do that through a state-owned entities. They will open up to private entities. And now these private entities are actually developing and are being given a valid legal title to explore these resources under a joint development agreement, but then they have a commercial dispute. It can be between the company and the joint entity created for the purpose of managing those resources, or it can be between two private entities working on the same oil field, where you have a cross-boundary, for example, of a deposit. That is sufficiently complex for me to make it comprehensible, but then you can see really how limited the role of mediation can be, and then it all comes down to the relevant aspects of the agreement that I have established with either the joint entity or with the states or with a national or with another national entity. So in closing, I would also mention the relevance of what Leah said, and we are seeing this now here in Portugal with the issue of the potential conflict between fishing communities and offshore renewable energy. It's now going. We are now seeing this. It's now ongoing. Sorry, and we are seeing a huge issue. And I was in a session organized by the government for presentation of the new program, and all the fisher representatives just got up, shouted, and were really aggressive, and everybody was in shock. And when they left the room, I knew one of them from other activities, and I said, "What just happened?" And he said, "I think it went really well." So all of that is part of the tactics. Thank you.
But it's true. In our interviews, the fishermen identified us as the next big conflict that we are going to have.
Really? Wow.
Yes.
Well, thank you very much, Vasco. You can talk about it later. And there is room for discussion, either here or at lunchtime. So, yeah, Vasco, thank you very much. I think the examples that you brought about the limits of mediation that cross a bit through the lines of mostly criminal issues, but also the question of enforceability are nowadays very important. Although I do not think this is a typical characteristic of mediation settlements, that they need to be directly enforceable, but they need to be able to be enforceable either through directly or through validation or homologation of a judge. Indeed, they need to have that kind of conformity, at least to some legal basis. So I liked it a lot. And regarding we discussed this offshore in the classes. I'm looking there at Velma, she's in the back. This offshore disputes on oil and gas, and some cases that were solved through mediation. This dispute between, I believe, was Lebanon and Israel, really because of oil offshore activities, or else they would never have solved it. And Velma just also gave us indications on Angola, for instance, when we have an enclave, Cabinda, quite difficult to manage for any other reason, but for oil and gas, they managed it, right? Because it's money, as it is Cliff put it. It's money. It's money for everyone. There's money involved for everyone. They just have to know how to split it up, and to split the money, they have to know how to establish limits. So thank you very much for saying this, which brings us back also to the experiences in our intensive course. So Roberta, now it's your turn to wrap this first part of our roundtable, and I give you the floor.
Thank you. I just want to start saying it is an honor to be here among great experts, colleagues, and friends. And just for the record, I wanted to say it has been an amazing experience to be part of this project. I've learned a lot. I've met great people. I made new friends, so it has been really good, and I'm very thankful that I was chosen to be here. So today I'm going to talk a little bit about what we have developed during this project, about the importance of maritime mediation to solve maritime conflicts. So why is maritime mediation so important for solving conflicts? I'm going to first talk about its characteristics and about how to foster it. Among its characteristics, we can mention confidentiality, voluntariness, and the fewer costs, the lesser costs compared to arbitration and litigation. It is a cheaper process, and because it is confidential, we have no numbers, but we can use, as an indication of its increasing use in the maritime area, an evidence, which is the increase of state legislation in the states, rules and model clauses published by the international commercial associations, such as the ICC, the LMAA, the Society for Maritime Arbitrators from New York, the Hong Kong International Arbitration Center, and not to mention the International Singapore Convention on Cross-Border Commercial Arbitration. Mediation is also a very important tool to solve conflicts among parties with an unbalanced power, such as the relationships that are developed in the maritime area. For example, among fishermen and the large corporate groups, or even with parties with the same economic power, but different bargaining powers in contracts. So mediation could really help with that. By being a self-composited means of solving conflicts without a third party inflict a decision on the parties that are in conflict, the result is less risky, meaning the risk of the parties being least unsatisfied with the result is smaller. Mediation is also one of the means of promoting the development sustainable goals, notably the Sustainable Development Goal 16, through the inclusion of the parties without economic or knowledgeable means to litigate or to arbitrate. So they have more access to find resolution of their conflict. But with all these benefits that I put it in a very summarized form, that some have been debated earlier, mediation is still under development, especially in some countries. So how can we foster mediation and more broadly develop the use of maritime mediation as a means of solving conflict? The first suggestion would be through the development of public policy instruments to stimulate parties to mediate and publicize their benefits. So Mr. Riskley mentioned earlier a very debated area, which is the possibility of sanctioning the party who is not willing to mediate. And I would mention here, especially when there is a mediation agreement. So the parties have an expectation of when emerging conflict arises, that the mediation will be the chosen method. So if the other party does not mediate, it will be, higher costs, higher time to solve the demand, and higher distress, because that was not expected. So that would be a possibility. There's also the possibility of instituting mandatory attempts of mediation. And I'm not talking about the mandatory obligation to settle, but just to attempt. Parties may, if gathered in a room where they have to just attempt, initiate a litigation, before initiating a litigation or an arbitration, just give it a try and see if mediation is reached. If the right environment is there, if the mediator is good, there is a possibility that might happen. The second means would be through education. This would be the basis for changing the mindset of maritime operators and legal operators, especially the legal operators in the maritime industry. If learning tools are given and there is a change in the mindset to always think first of mediation as the first attempt, the first alternative, the legal systems would be more effective and more efficient, less crowded, with fewer frivolous cases, like we have a lot in some countries. I would mention here Brazil, especially. And all the benefits of mediating would emerge. For some law operators, litigation is their main alternative simply because they have been educated to think that way. So that was, the mindset for that. It is also through education that we make our third suggestion, the formation of accredited mediators in the maritime area is an important step towards bringing the necessary reliance and expert knowledge to allow parties to attempt to mediate. So when you solve a conflict by the hands of an accredited mediators, it will make it possible to solve conflicts in a more efficient, less costly, and beneficial means. As the legal system is seen in its entirety, the contribution of the judicial system, lawyers, and arbitrators is essential and play an important role in the development of mediator. So when legislation allows, judges can promote on-court mediations and are also benefited from it. And lawyers, understanding how it is an important tool for the development of their clients' interests, could also become developers of mediation. And finally, I would mention arbitration, because it has a key role in supporting mediation, as some international and domestic arbitration centers are also the ones to publicize rules for mediation, mediation clauses, and mediation procedures. Mediation and arbitration may be, to some extent, complementary procedures. So these are the points I intended on talking today, and I remain open for the debate and questions. Thank you.
Thank you very much, Roberta. Roberta already advanced some of the issues I wanted to ask the other participants in this roundtable. So I will just catch your line and go on from there. So I think we all agree that there is a need for mediation. What type of mediation, limits of mediation, it's still a bit of a blur, and something that you might not even be able to define in anticipation and in general. So, but it could be the first option if it's available, if it's adequate. But if we do agree on that, what is still lacking for mediation to be relevant, at least in our, in Portugal and in the systems we know. We saw this talking about UK, where this is very flourishing, Asian, there's a lot of practice in mediation and other places, but in continental terms, if we may put this, Norway still we have some also, but they will talk about it. Stian will talk a bit about it afterwards. But here it seems like what's lacking? There's interest, legislation is coming, but we saw yesterday there's a lack of practice. So what do we need to, what is your impression of what do we need to do to make it more relevant? Yeah, Fatima, start. Let's change a little bit.
I see maybe the lack of awareness of the maritime mediation benefits of maritime mediation. What is maritime mediation? What is mediation sometimes than that? And maybe the sort of capacity building initiatives like this would be an asset and be something to change and to start to create this awareness and understanding of the benefits of mediation. And well, maybe the training too. It's an idea. I think Leah spent last week training students and the mediation. And I think Sarah, many ideas identified.
Thank you, Fatima. Thank you, Leah.
I think it's evolving because even in marine protected areas, for example, there was a legislation that came out recently that allows for setting up co-management in these areas.
Yeah.
So we are seeing it changing. So for that, they did a process of mediation before proposing. So it's very important, and I have been seeing that it's evolving. We probably did the first one, Margot, that was a big one, but I think now we are seeing other groups. This was WWF in Portugal that started a mediation process, and at the end they were able to have legislation for allowing the setting up of co-management place. So I think there are changes.
This also shows the several phases that mediation sometimes of facilitation may go to in this situations where there are conflicts and disputes, they're all around, but you just cannot, well, you cannot solve just one. So you need to change the framework, and in some cases you need to change the legal framework.
There is another thing that's quite obvious. People set up the conflict and then they ask us if we can solve it instead of preventing it, you know. And it happened already twice, at least, that I was invited to solve a conflict that they had created. One was the Port Authority, and the other was a municipality. And what they wanted was not the conflict solved. They wanted marketing.
They're basically, they're basically, yeah, that's
so,
true.
I think there is also some lack of understanding or trying to have an opportunity to overcome the conflict in marketing terms.
Yeah, that's also a bit, shows a bit of not full knowledge of what mediation is, because mediation, it has communication issues that when public entities are involved mostly, but it's not a mechanism. It's a mechanism that's should be the most balanced possible. Thank you, Leah. Pash, can you?
Well, I think it comes to my first point, not being very legalistic, but what is mediation in terms of concept under Portuguese law? Because, for example, we under the rules that Leah was mentioning, if you look at marine spatial planning, our legislation has this first tier of dispute settlement, which is the conciliation committee, which has nothing to do with conciliation under international law. Conciliation under international law is very specific, it's very distinguished from others. forms of settlement. So, but for the purpose of Portuguese law, that conciliation means trying to bring conflicting views or uses and activities and finding a way of solving that conflict, extrajudiciary settlement. The outcome of which is not a settlement. The outcome of which is determining forming an administrative decision on which use will prevail. It doesn't solve the conflict between two private entities. It solves the conflict regarding the use of the maritime public domain. So they're very different things. Also, if you look at what we have in consumer protection, 20 years ago, we developed something, I don't know how to say this in English, os julgados de paz. I don't know how you say this in English, but
For peace.
no, they're not for peace. Right. They're actually there to solve issues either in the so in Portugal 30 years ago, ports were packed. You could not get, times were unbelievable, particularly involving the administrative. Well, it's still difficult, but so there were many issues dealing with consumer law, issues dealing with management of joint property, or you can, all of these small cases that are worth nothing in terms of legal substance or value or economic value, but they would just, block the court nonetheless. So they were settled outside, and what you get at the end is not a sentence. You get a decision to which both agree to. Is that mediation? Is that a form of mediation? How does that fall within the issue, the problem of conceptualization under each jurisdiction? So there are all of these different perspectives. Why do I think that the kind of mediation that I believe we're discussing here, so from my understanding, has to do with also the way that the legal practices are formed here. We saw from our keynote speaker reference to solicitors, barrister, master of the robes. All of these positions do not exist in continental law. We do not distinguish between the legal practice as such. So, for example, I was doing oral exams to future to be judges a few weeks ago. And you can distinguish what is potentially a good candidate from a bad candidate. A bad candidate would be a lawyer who would tell you, oh, I have a legal practice, and you ask, have you been to court often? No, because one of my qualities is I mediate conflicts. So I see there is a dispute, I come to the different opposing parties, and I will solve it. I have very good skills, I can solve this. And what we, the jury, are listening is, I don't know enough law, I don't know how to protect this case in court, and therefore I always try and find a settlement. So it doesn't matter who is right or wrong from a legal point of view, everybody's happy, but the legal issue is not solved. So, and this is a different attitude from continental law to common law, where, for example, a lot of, and if you see, I always tell my students when they're going through certain specific areas of law in our law degrees, don't watch Netflix series on American judicial system. You'll get confused. Not even our jury process works as a jury process in the US. It's very different, thank God. It's very, very different. And the whole issue of the validity of an agreement. For example, we saw now this issue with Titan, right? All of the people that died on board signed a disclaimer they would never sue the company. Such a disclaimer in most countries, if not all countries of continental law, is inadmissible. So such an agreement, well put together by a common law lawyer, bulletproof, then here it doesn't work. I remember being an expert for a case in the US, for a court in the case, and the question was the enforceability of a contract. And they wanted this thing, which was not a contract in the US, to be enforceable here, so that the Portuguese banks would release the amounts of money to the relevant party. None of that is admissible. No court in Portugal. So we have this saying in Portugal, and I'll shut up with this, that we have a saying in Portugal that we learn when you're going through the bar exam. rather a bad, no, Miguel? Rather a bad agreement than a good day in court. But that is not made, but that is not said. That is so that the lawyer is not the jockey on a horse to litigate and to entice parties to litigate. That's what the purpose of the saying. The saying is not try not to go to court, try to settle it outside court, because that is a different perspective between continental law and common law, where dispute settlement outside court is favorable, whereas in continental law, we see the role of the judge and the intervention of judge very different. So I think the issue of conceptualization, I know that this is the end of the project. Conceptualization, I think it's very interesting. Sorry.
Thank you, Raj. Well, I'll open the, maybe Roberto already talked about this. You want to add something to it?
No, I would just add that I think that the legislation in general, like specific maritime legislation, needs a little bit of an update because it's old. It's from 78, I think. With the conciliation, and it refers to conciliation in some specific. I don't remember the number of the decree here in Portugal, but it refers to mandatory conciliation by the port captain in some cases. So I think
it's adjustment.
Yeah, it needs an adjustment. It's the same in Brazil. It's also a legislation that is very traditional, so it needs to be stated.
Thank you. So I'll open the floor to questions. We still have 10 minutes, I think. Licinia, anyone else? Well, Licinia, please.
So thank you so much, for the very interesting roundtable. It has raised a lot of questions and issues. I was very taken back by what Ashton was mentioning about the complexity of international maritime law and the complex and context of the Dead Sea, which would make all of the issues more complex in the coming future. I come from the background of international relations, so I'm interested in this sort of thing. And looking at that, I wanted to ask you, because is the one who can help you most, what the environmental perspective. So we are discussing a series of activities that see commercial and economic activities, but we do have a series of agreements and targets politically defined and established that have to do with the preservation of the environment, the preservation of biodiversity. One, these have different force in terms of in legal terms, I imagine. We do have cases where people are trying to sue states for missing on their obligations and due to the impact that has on communities, the environmental impact and access to natural resources. So is that a new area where we can see perhaps more traditional activities around environmental issues, and what can we do in advance before moving to the
I can tell you what I think it will happen. I think what's going to happen, and it has already happened in some of the cases, is they go for the European Union. So the people that are against it, because what it's happening is the privatization of the sea. That's exactly what's happening. And that's the big issue. It's not a small thing. And but the small communities probably are going to get organized, and what they will look for is for something outside the country to try to make pressure on the country. That's usually what happens in these situations of environmental conflict. Because they need to have power over the governmental decisions. I know there are lots of laws that protect, but they can invoke the law and nothing happens. We have seen that. So that's what usually happens, is that they recur to a higher level decision making. Yes.
Or to the European Court on Human Rights. There is already an action that was introduced by Portuguese children, not specifically on maritime issues, most to do to the fires occurred in 2017 and to all the impact it had in their lives and in intergenerational issues and discrimination. So we're still waiting for a decision on that, but very surprisingly, the European Court on Human Rights accepted the claim, which was already a big win. So we're waiting for that. Besides, of course, decisions, and maybe Vasco will talk a little bit about that more, decisions that are also, not every country has like this bad relationship in what regards this protection. We already have some cases in some countries where the countries do decide on the positive to environmental claims, for instance, Poland, Germany, but I'll leave it to you.
It's a great question. At sea, things are very different. Because the biggest challenge we have is the reality, the public discourse that you mentioned, and the citizen around the world is far more aware and far less tolerant with inaction. However, international law has not developed at that speed, and the rules applicable to liability and responsibility of a state are still very much the same as they were when we were revisiting the articles on draft responsibility, and very much it is not possible to say that there is a collective right of states or citizens to act against a state for not acting on issues regarding protection of the marine environment. However, we do have tools that are quite effective, and they are recent in some respect. We do not have the concept of environmental crime. Environmental crime only exists under domestic law when it exists, but there is no such thing as international environmental crime. So that action is not punishable. The only way you can exercise that is if the jurisdiction of one state recognizes that that crime exists and that crime can be tried in its national court. The only state that I am aware that does this successfully for many, many years is the United States. And they do this successfully because they use whistleblower remuneration as part of the process. And you'll be surprised that pollution is not, the larger act of pollution are happening actually in the tourism industry, the luxury cruise liners, all that. And those are the actions being successfully sued in the United States. Also because the United States have a very long established tradition dating back to the 18th century of exercising extraterritorial jurisdiction, which then they try always to stretch beyond towards, and that can also be successful. On the other hand, there has been a very important shift on a case that was brought against Shell for acts committed in Nigeria. What happened with most countries until recently was Shell company in The Hague had shareholders in Shell company in Nigeria, but the actions were never attributed to the mother company, but to of course, the company in Nigeria had no asset. So they managed to convince a court in The Hague that the mother company would be responsible, because you cannot distinguish these two. That the company has the benefit, the shareholder has a benefit, but it has no responsibility. This happens still today with everyone, you know, and this was a very important move. The other second important move was when we had deep sea horizon collapse, the offshore drill, where belonging to BP, the shareholder is in the UK. Of course, that offshore drilling platform wasn't registered, was under the jurisdiction, in that case, of the state of Louisiana, if my memory is correct. But they managed to build a reasonable legal argument to sustain that it would not be possible to maintain this disconnect between ultimate responsibility and the action. So we are seeing this shift happening. People are becoming more aware, but these are baby steps compared to just to give you an idea, when Deep Sea Horizon collapsed, we had to revisit the protocols based on which funding for compensation of oil pollution. They were very small compared to the impact because nobody had predicted. So we now know that these impacts, but there are many other problems happening now. Release of nuclear waste into the ocean. We thought this was something from the past, but now we see that, for example, Japan is unable to deal with one element of the Fukushima power plant, and they've built this scientific case to say that actually it's the only way to do it that is environmental friendly, is to dump it in the Pacific Ocean. I don't know how to say it, it's tritium or something, which is one component of the tritanium. I don't know how you say it. It's one component. Which is the better? What Japan says, this is not infringing international law, it's not dumping. But it is dumping under dumping convention, under dumping definition of the United Nations Law of the Sea. Does that entail such responsibility? Where could you sue Japan? The only state where you could sue Japan is in a Japanese court. But is it? Or can we stretch international law and find another place where we could successfully sue? On the issue of the European Court of Human Rights, it's true. You could not bring a case in the Tribunal of Justice of the European Union that will not find it admissible, but in the European Court of Human Rights, it is possible. The question is always not the admissibility, that's very important, but what remedy will the court then be able to identify and who will benefit? Will this NGO in Portugal of kids be able to bring a case against, let's say, a company that is based on another state for damages that happen in the third state? Would the European Court of Human Rights finding jurisdiction is the easy part? Well, not always, but easy part. But then it's, okay, is there a remedy and to whom do I afford this remedy? It has to be to the plaintiff. So there are difficult things. I think we are now in a very exciting stage where we are seeing that there's more, it's a fine line between stretching the law and judicial activism. It's always a very fine line, but it's a very interesting line. So if anybody is looking for a topic for a PhD, please invite me.
Well, we have some PhD students in the room, so who knows? I think we have to go to lunch because everyone wants to talk in parallel. So, I close this session with thanks everyone involved, participants, organization. We'll come back still. We'll come back at 2. I'm just saying this because we will close the YouTube transmission, but we'll be here to finalize the work plan of the day. And in the meanwhile, I will distribute also our small tokens of appreciation to our panelists from this roundtable, and then we'll proceed to a dessert break for lunch. So,
Eu peguei a orelha desse mais não. Eu já lhe conto.
Eu já escrevi sobre jurisdições de material.
Sim.
so we can
Aceita disso. Obrigada.
That's yesterday. So let's close this session and see everyone at 2. Ok, como é que eu faço? Desligo, não é? Encerro o